seated. Court will be in session. All right, court's going to start with some cases that I've been made aware are ready for a plea at this time. We'll start. First case the court's going to call is 2019-2 State of Arkansas versus Robert Chapman. Mr. Chapman, you're appearing at this time to change your plea on a charge of theft of property. Is that correct?
Yes, sir.
And this change of plea is brought about by an agreement that's been worked out for you by your attorney, Mr. Cooper. Is that correct?
Yes, sir.
Have you discussed the terms of the agreement and the punishment you're to receive with Mr. Cooper?
Yes, sir.
Do you feel you understand the agreement?
Yes, sir.
Are you satisfied with the advice and the representation you've had from Mr. Cooper?
Yes, sir.
On the charge, in this case, of theft of property, a Class D felony, on that charge, how do you now plead?
No contest.
You're in this plea of no contest pursuant to an agreement that's been worked out for you by your attorney, and that agreement is set out in writing in the document I'm holding up called a plea statement.
Yes, sir.
Have you read through and signed this plea statement?
Yes, sir.
Do you feel you understand what's set out in the plea statement?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand, pursuant to the plea statement, that there are constitutional rights that you give up by pleading guilty?
Yes, sir.
Those rights that you give up by pleading guilty are set out in the plea statement. They basically include the right to a jury trial, the right to have an attorney represent you and assist you throughout that trial, the right to confront witnesses that would appear and testify against you at trial, and finally the right to appeal. All of those are rights that you are giving up by pleading guilty. Do you understand that?
Yes, sir.
And understanding that these rights that you're giving up, are you still willing to enter this plea of no contest?
Yes, sir.
No contest?
Yes, sir.
Are you entering this plea of no contest freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
No, sir.
Based on those statements, the court's going to find the defendant has freely and voluntarily entered his plea of no contest, done so after consulting an attorney, and that he's and the court is accepting his plea of no contest at this time. I'll call upon the state to provide the court with a factual basis for the crime.
Your Honor, information was provided to the Baxter County Sheriff's Office concerning the theft of a 2003 Yamaha Tracker 250 ATV. Upon investigation by the Baxter County Sheriff's Office, it was determined that a Yamaha 250 ATV had been stolen from an individual. They had made a report that this four-wheeler had been left in a location. They went back to the location and found the four-wheeler was no longer there. Contact was made with the defendant in this matter. That contact came based upon information being provided through social media of a four-wheeler being for sale. Said four-wheeler matched the description of the complainant's four-wheeler. The VIN and identification numbers also were correct with the information provided by the victim in this matter. Said four-wheeler was retrieved by the Baxter County Sheriff's Office and was the one that was identified by the victim in this matter.
Based on that information provided, with the court having found the defendant, having accepted the defendant's guilty plea of no contest, at this time the court accepts the defendant's plea and judges the defendant guilty of the offense of theft of property, a Class D felony. The court will sentence the defendant in accordance with the agreement to 4 years of supervised probation, subject to the standard terms and conditions of probation. Court's imposing court costs of $200, a fine of $2,000, statutory DNA fine of $250, public administration fee of $20, public defender fees of $200. All of those amounts will be due and payable as a term and condition of the defendant's probationary sentence, with payments to be made in regular monthly installments of not less than $100 per month beginning within 30 days of this date. In placing the defendant on probation, the defendant will be subject to the standard terms and conditions of probation, which the court has reviewed and signed, making them an order of this court that he comply with. And the court is noting that the defendant has signed them as well, indicating he has read, understands, and will comply with terms and conditions of probation. At this time, Mr. Chapman, I'm directing you to meet with the probation officer, get set up on probation. You may be excused.
Thank you.
Call 2019-192, State of Arkansas versus Crystal Hodge. Ms. Hodge, you're appearing at this time. Are you represented by counsel? Oh, I'm sorry. Are you appearing at this time pursuant to an agreement that's been worked out for you? Is that correct?
Yes, sir.
And have you discussed, this was worked out for you by your attorney, Mr. Cooper, is that correct?
Yes, sir.
Have you discussed the terms of this agreement and the punishment you're to receive with your
Yes, sir.
attorney? Do you feel you understand what the agreement is?
Yes, sir.
And are you satisfied with the advice and the representation you've had from your attorney?
Yes, sir.
On the charges of possession of a controlled substance, a Class C felony, and possession of drug paraphernalia, a Class D felony, on those two charges, how do you now plead?
Guilty.
You're in this plea of guilty pursuant to the agreement we made reference to. That agreement is set out in this written plea statement that I'm holding up at this time. Have you read through and signed this plea statement?
Yes, sir.
And again, did you understand what was set out in it?
Yes, sir.
So you understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand that when you plead guilty, you give up certain constitutional rights?
Yes, sir.
The most important right that you give up is your right to a jury trial. But with that right to a jury trial, you're also giving up the right to have an attorney. When you give that up, you're having the right to have an attorney represent you throughout that trial process. Furthermore, you're giving up the right to confront witnesses that would appear and testify against you at trial. And finally, you're giving up the right to appeal. Do you understand these rights you're giving up?
Yes, sir.
And understanding what rights you're giving up, are you still willing to plead guilty?
Yes, sir.
As you enter this plea, are you doing so freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
Yes, sir.
In pleading guilty here today, are you acknowledging your actions that constitute the crime?
Yes, sir.
Are you acknowledging that on or about May 19th, 2019 here in Baxter County, that you were in a vehicle that was stopped and that the officers found in your possession a quantity of I believe it's methamphetamine, is that
Yes,
correct?
sir.
And also paraphernalia related to the use of methamphetamine?
Yes, sir.
Based on those charges, those statements, the court is going to find that the defendant has freely and voluntarily entered her plea of guilty, done so after consulting an attorney, and has admitted to her actions that constitute the basis of the crime. On that basis, the court accepts the defendant's plea of guilty. The judges the defendant guilty of possession of controlled substance, Class C felony, possession of drug paraphernalia, Class D felony, and at this time, in accordance with the agreement, will sentence the defendant to 6 years of supervised probation on each felony offense, run those sentences concurrent, and then the sentences will be suspended. The defendant placed on probation, subject to the standard terms and conditions of probation. Court is imposing $200 court costs, a fine of $2,000, statutory DNA fine of $250, book administration fee of $20, drug crime assessment $125, and $200 in public defender fee. All of those amounts will be due and payable over the course of the defendant's probationary sentence, with payments to be made in regular monthly installments of not less than $100 per month. The first payment will be due within 30 days of this date. and then continue each month thereafter. Court, once again, is directing that this defendant will be set up on probation. The court has reviewed the terms and conditions of probation and signed them, making them an order of this court that you have to comply with the terms and conditions of probation. The court also notes that the defendant herself has signed them, indicating that she has read, understands, and will comply with the terms and conditions of probation. At this time, the court's going to direct the defendant to meet with the probation officer and get set up on probation.
Okay.
All right, you may be excused. Court is calling 2017 458, 2018 303, State of Arkansas, Mrs. Jessica Schaefer. What are the circumstances of her appearance here today?
Your Honor, Mrs. Schaefer had been sentenced by the court, and as a term and condition of her probation, she was due 1 year in the Community Correction Center. Community Correction Centers have removed her for violations, and so she has to reappear before this court to be resentenced, Your Honor, based on the violations of those terms and conditions, Your Honor.
So at this point, there's no agreement on that.
Your Honor, no, she was just brought up, I believe, overnight, and I was informed that she was in our jail this morning. And Mr. Etheridge and I have not even had a chance to speak about Ms. Schaefer.
I see. This is a new petition to revoke and filed July 30th, 2019. It alleges that
Yeah.
while in the community corrections facility, she violated the condition regarding treatment and counseling, and the second condition she violated was one involving cooperation and honesty. Apparently, she was seen before the disciplinary hearing committee of the Northwest Arkansas Community Corrections Center, and recommended that her probation be revoked. It alleges that she has been seen by the disciplinary hearing committee 5 times in less than 30 days. Despite consequences, she continued to engage in non-compliance, disrespect of the staff, and refusal to follow orders by the staff. She doesn't participate in the modified therapeutic community program. She refused to comply with learning experiences or sanctions, and has shown herself to be both belligerent and hostile, as well as disrespectful towards various officers and staff personnel. On that basis, she's now before the court. Mr. Cooper, have you had any chance to discuss this with her?
Your Honor, I have, Judge, I think this is a new case now. It's the revocation, so she'll need to fill out a new application. Obviously, she's going to qualify since she's been in CCC. I'll enter a plea if not true on her behalf. I'll ask her to fill out an application. Your Honor, I want some time to go over this with her. She is very much disputing these allegations, and so we need at least 2 weeks, Your Honor, if not longer, for what probably will be a revocation hearing from what she is telling me this morning.
I'm noting a plea if not true. Have her fill out the required form, and let's get this set up. We're back here on, I'll make sure.
Your Honor, I don't want, however the court wants to handle this, again, there are 2 cases. There was 458, but this plea came out of 303. I guess technically 303 would be on Judge Putnam's docket, Your Honor. He took the plea. It does not matter to, again, they're all mine, so it doesn't matter to me, but I want the court to be aware of that. If you want to put it on his docket, that's fine, and and I can take care of it over there. It makes me no difference, Your Honor.
I'm gonna set it down then for the 8th of August in front of Judge Butler. Down for August 8th in front of Judge Butler.
Your Honor, so she is aware, we would be prepared to move forward having a hearing on that day. We can have our people available that day, Your Honor. And she'd be on no bond. We would ask her, she'd be held with no bond because she technically is in violation, so there's no way we can let her out, Your Honor.
Exactly.
Your Honor, we'll advise Mr. Hastings of what Mr. Etheridge just said about what their intentions are from the state.
There'll be a no bond hold. She'll be down for hearing on August 8th. You may be seated.
Thank you, sir.
Court's making the appointment for Mr. Stephen Nizio in cases 2019-231 and 2019-232. Jay, you make sure he's already been arraigned on these.
I'm not sure, Judge.
I arraigned him on June 20th. They're set for both cases. These two new cases are both set for trial the week of October 21st with a reappearance on September 12th. And there's an earlier case, it's a drug case, drug delivery case, is 2018-447. It's set down for appearance today, and it's set for trial during the week of August 19th.
Your Honor, it can stay on the trial docket for now for the week of August 19th.
Let's see if we can't get that, at least that one off. So we'll move on to the next.
Your Honor, if we could have him reappear on the 15th, and Mr. Etheridge and I are in conversation based upon what Mr. Nizzle and I had spoken about, and hopefully we can have some resolution by the 15th.
All right. All right, Mr. Nizio, you may be excused at this time. Your next appearance in court will be August 15th. Okay, I'm going to call State of Arkansas versus Kyle Tilley. We've got 2019-155, 2019-149, 2019-96, 2019-280, 2019-289. 280 and 289 are for arraignments, my understanding. So let me go through these here. The court is making the appointment of the Public Defender's Office to represent Mr. Tilley in cases 2019-280 and 2019-289. 2018-189. Tilley is for arraignment on residential burglary, Class B felony, and theft of property, Class C felony, and misdemeanor criminal mischief, and fleeing, Class D felony. And those charges, where's defendant plea?
Not guilty, Your Honor. Your Honor, that would, he has pending cases on your docket, so if there's any cases, I think this is one that would be on Judge Putman's docket. We ask that it be transferred to Division 4.
I'm going to transfer it to Division 4, because of all the other cases that either are on them docket or have already been transferred to my docket. This case will be the plea of not guilty as noted. The case is set for trial during the week of November 18th. And set for I'm going to set it for reappearance. He's got one case already set on a burglary. It's a burglary case. for trial during the week of August 19th. We're going to keep it there. I want to see if we can't get that resolved. And then we've got two cases that are both involved thefts set for the week of September 16th. I'm leaving those there.
That's fine.
And we're going to get these cases off the docket. If we don't, we'll just fall behind on Mr. Tillman. Again, I've noticed plea of not guilty, transferring 2,289 to Division 4, setting it for trial during the week of November 18th. I'm going to set him to reappear on August 15th in hopes that there'll be some discussion of a resolution on August 15th in advance of August 19th. Now on case 2019-280. We've set that by scheduling an order for October 21st. Oh, that's for arraignment also. Let's get the arraignment out. This is for arraignment again on residential burglary, breaking or entering, theft of property, separate misdemeanor theft of property. The felony is a theft of firearm, and misdemeanors other property, apparently. On those charges, how do we have to play?
Not guilty, Your Honor.
We're setting that by scheduling order for trial the week of the 24th with a reappearance on September 26th. That scheduling order is already entered. Once again, he has those 5 cases and the trial's coming up. Bond on the defendant's cases, there's 2 new burglary cases. Set at $25,000 cash only bond on both of them. That's where we are. You may be excused, sir.